Welcome to this module on election petitions. Here, we'll explore disputes related to elections for various legislative bodies and local self-governments, including MLA, MLC, Rajya Sabha, Lok Sabha, Panchayats, and municipalities. So, what exactly is an election petition? Simply put, it's an application used to challenge an election result. It's important to note, it's not considered a typical lawsuit or an appeal. Its main purpose is to contest the results of parliamentary, local government, or state government body elections. When we talk about the context of elections, various factors can influence outcomes, such as the destructive role of money power, the fear created by violence and criminalization, or even communalization based on identity politics. Low polling percentages can also indicate that only specific groups are influencing results, and sadly, illiteracy can lead to voters being influenced without proper consideration. Election petitions can be filed to challenge results for a wide range of seats. This includes members of Legislative Assembly, or MLAs, and members of Legislative Council, or MLCs. At the Union Parliament level, they can challenge results for Lok Sabha, the House of the People, and Rajya Sabha, the Council of States. They also apply to local self-governments like panchayats at the village level and municipalities in urban areas. Let's look at the statutory framework and jurisdiction. The primary guiding legislation is the Representation of the People Acts of 1950 and 1951. These acts provide the complete framework, including filing deadlines and specific grounds. For instance, Section 100 of the 1951 Act outlines the grounds for declaring an election void, and Section 123 defines corrupt practices. When it comes to jurisdiction, election petitions are always filed in the High Court of the state where the election took place. This was a significant change, assigned to high courts by the 19th Constitutional Amendment in 1966, moving it away from tribunals. The Chief Justice of the High Court has the discretion to assign one or more judges to hear a petition, meaning it could be heard by a single judge or a division bench. If there's an appeal against the High Court's decision, it can be filed in the Supreme Court. Now, who can actually file an election petition, and what are the requirements? Generally, an election candidate, or any person directly or indirectly related to the election, can file one. There's a strict timeline. The petition must be filed within 45 days from the date the election result is declared. Do note that special timelines might apply for panchayat and municipality contexts. As for the filing fee, a security deposit of 2,000 rupees must be submitted with the petition, though this amount can vary from state to state. An election can be declared void based on several specific grounds, as detailed under Section 100 of the Representation of the People Act, 1951. These include, if the returned candidate was unqualified or disqualified on the election date, if the returned candidate, their election agent, or anyone with their consent committed corrupt practices as defined in Section 123, if there was improper nomination, acceptance, or rejection of any candidate's nomination, or if the election result was materially affected by improper receipt, refusal, or rejection of any vote, or by non-compliance with the Constitution, the Representation of the People Act, or any related. Let's look at what an election petition must contain and the procedure involved. The petition needs a clear statement of all material facts, full particulars of any alleged corrupt practices, and a statement specifying the relief the petitioner is seeking. It must list the names of all parties, be signed by the petitioner, and duly verified. Crucially, it needs to be accompanied by an affidavit confirming that the allegations are true to the petitioner's knowledge and belief. Any mentioned schedules or annexures must also be included. The trials themselves are conducted by the High Court, and evidence, including affidavits and proofs, is required. The process can also involve provisions for recounts and the enforcement of the final judgment. An election petition can end in two ways before a judgment: through withdrawal or abatement. For withdrawal, a formal application must be made. A notice, including the hearing date for the withdrawal application, must be provided to all other parties and also published in the official gazette. Abatement means the petition ceases to exist or loses its legal force. This typically happens upon the death of the sole petitioner, or if there were multiple petitioners, upon the death of all of them. In such cases, the High Court will then direct the appropriate manner for proceeding. Finally, let's touch upon a landmark case, State of Uttar Pradesh versus Raj Narain from 1975. This case is highly significant as it played a crucial role in the events leading up to the declaration of the emergency in India. Rajya filed an election petition challenging the election of then Prime Minister Indira Gandhi, alleging corrupt practices, specifically that she had used a government official for her election campaign. The outcome was momentous. The Allahabad High Court found against Mrs. Gandhi, declared her election void, and consequently she was removed from the position of Prime Minister. The High Court also barred her from contesting elections for 6 years. Thank you for listening. Welcome to this